I'm not a great fan of the idea of arbitration for trust cases. It seems to me that a lot of the arguments that are advanced in favor of it aren't completely persuasive. I mean, I think the strongest argument is that it's often desirable for any proceedings relating to trust to be heard privately so that the affairs, which may be family affairs, remain confidential. And certainly among high net worth individuals and ultra high net worth individuals, questions of security and so on play quite a significant part. I think the answer to that is for the courts not merely to leave things as they are, but to go back to the greater readiness of that one used to see of the courts to hear these matters in private. In the UK, there's been a very marked shift away from the idea that these are private matters and the court should deal with them in camera. It used to be a matter of routine that you just stand up in court and the first thing you'd say is, "Well, can you hear this in camera?" and everyone will be cleared out without any argument. Now you have to put forward fairly compelling reasons for excluding the general public and the press, even, of course, if the court is already empty. The offshore jurisdiction...
Well, the best way to fill a courtroom is to ask to do it in camera, and then
yes.
Immediately everyone rushes there. It must be exciting.
Quite. I think the offshore jurisdictions are, to my mind, rather more accommodating and pragmatic about this. And so far, my experience in the offshore jurisdictions is that the courts are very much as willing as they used to be to hear matters in private, and if they feel that the judgment is one that requires general reporting, to redact the judgment so it's anonymized and it's only the principle of law that gets reported. The other arguments that are put forward are that it enables the trustees or the parties to choose expert judges. Well, how popular that is, I've noticed, tends to be a function of how confident the practitioners are in their local judiciary. And in places like Jersey and the UK, and I would say also Cayman and Bermuda, which have very strong judges and very good local lawyers, I don't think there is such a strong appetite for arbitration on that basis. On the other hand, people from the Middle East, from China, from Russia, and so on, tend to be much more interested in the possibility of being able to select who is going to decide their cases. There are other arguments to put forward. No appeal, or it's very difficult to appeal. To my mind, that's a very bad argument. I mean, all judges get things wrong, all tribunals get things wrong, and the opportunity to put right mistakes through a series of appeals seems to me entirely desirable. In contrast with commercial businesses which may simply want finality, I think settlors dealing with their own private wealth and the parties are much more likely to want the right answer rather than any answer.
Steve, because we are going to run out of time, if we're just sort of stepping back, maybe on arbitration or on the other ones, I mean, which of these areas do you think poses the biggest challenge, or do you think is going to face the sort of biggest uphill battle, at least in terms of drafting? Because the very good advice, the esteemed advice that's coming from this panel is that some of these good ideas are great, but good luck actually doing it. Which one do you think will be the hardest?
Probably getting the balance right on beneficiaries' rights, if we're going to do anything at all, because I think there is an argument for saying just leave it be. As Gilead said, we've had some judgments on the topic since 1984, so other than potentially clarifying the slight element of uncertainty there is in the opening words, the best argument might be to leave that one alone. Personally, I mean, Jeff commented earlier that our law is very strong. I don't think there's anything in this current consultation paper which, from a Jersey PLC point of view, is anywhere near as important as the changes we made in 2006, getting rid of the perpetuity period, reserve powers. They, I think, really did give us a competitive edge against other jurisdictions in terms of winning trust business. But nonetheless, I think it's right that we consult